Kindly to. Just sit. Okay. Okay, then just sit there then. Oh, sorry. So let me just good morning. I hope you had a restful night. Na mmeamka vizuri. So let me just confirm if our 8 teams proceeding, if we have all of you here. So SC005. Oh, you are here. Okay. SC013. Okay, you are here. SC001. Okay. SC016. Okay. SC011. Okay. SC002. Okay. SC009. And then, yeah, lastly, SC015. Okay, sir. So thanks. We'll do the casting of lots shortly to know who is meeting which other team and whether you are applicant or respondent. So just shortly, then we'll start. After that, you'll go to your court for the quarterfinal. So we are now ready for casting of the ballot. So we'll have a representative from just the way we did yesterday. So one of you from each team, each of the 8 teams, send your representative over. Okay, so I'll invite over Alex, who will guide you in the casting.
Good morning. I hope everyone remembers their number, their code. So I want somebody to confirm these are 8 ballots. One of you. Don't open. Somebody to confirm that box is empty and hand it over to me. Check whether I'm putting something else. So you will pick one and don't open until we pick all of us. Just one. So you can open your ballot. And once you open, you come see Stanyambana.
See you and now you are.
Yeah, well,
Yes.
code. Now you're
See you
using your
soon.
code.
Let's look at that.
Sorry. You come?
S is 4, S is 6.
Six. Don't do 6. This you want to see this. Yes. This flip it, you see it.
SC02.
Will be in the photocopy.
Okay, so thanks. So we are done with the casting of lots, and now quarterfinals will be as follows. Those who will be going to the library up there, I'm sure you remember, that's court 1. SC009 will be applicants, then SC013 will be respondents. That is at the library, court 1. Estarina will be the one guiding you. Then court 2, Supreme Court 4, that's those who are remaining here with Jane. So SC001 will be applicants, and then SC015 will be respondents. That's those who are remaining here. Then court 3, Court of Appeal ground floor, that's just the one next somewhere here. And SC016 will be applicants, SC011 will be respondents, so you'll be with Brian. Then court 4, lastly, Court of Appeal, the one next, is it first floor? And I'm sure you know the other side. So those who will be there will be SC02 as applicants, and SC05 will be with Alex. So up to this stage, is there any question, any concern? I think everybody, we are on the same page. So I'll just ask, I'll invite my colleague Sam to pray for us, then we disperse to our respective courts.
Let us pray. Dear Heavenly Father, we come before you today. We're thanking you for your mercies. We're thanking you for your journey mercies, even as we have come from our respective places until we have converged at the Supreme Court, O Lord. We're thanking you for the occasion that is in the Moot Court. We're thanking you for yesterday and what we did yesterday, and that it was successful. We come back to you with gratefulness in our hearts and with joy and thanksgiving, O Lord. And even as we look forward for the competition today, we pray that you go before us, give us the intellect, given the knowledge that we desire, give us the administrative values that will enrich the Moot Court competition, O Lord. And even as the occasion will come to a halt tomorrow, O Lord, at the finals, we pray that the same will be successful, and we will also come back to you with gratefulness and thanksgiving, O Lord. We pray this shortly and believing in your holy name. Amen.
Good morning, ladies and gentlemen, and welcome to Supreme Court of Kenya for the quarterfinals Moot Court Competition 2025 series. The matter is Nyota Refugee Coalition and another versus Minister for Homeland Security and another. The presiding judge for the day is Honorable Bernard Kasavuli, whom I will welcome to introduce other judges. You're welcome, sir.
Okay, thank you so much. I want to take this opportunity to welcome you for this second day of the competition. We hope you enjoyed yesterday and you have had a restful night, ready to deal with today. My name is Bernard Kasavuli. I am presiding over, and I'm assisted by my colleagues here. On my right, Honorable Njagi, and on my left, Honorable Caroline Mugo. So you are welcome. Feel free and do your best. We wish you well. So we will start with the small preliminaries. After yesterday's brief, we hope the teams before us, all the oralists are making presentations, and so if that be the case, we will be able to know. If it's not the case, we will also know. So I think we can start.
Maybe by the permission of the court, if the bailiff would show me the timer as I'm submitting. May it please the court, presiding judge, your ladyships. My name is Ayaga Max Liambila for the appellants, alongside Ms. Joy Mweke and Mr. Kelvin Nyaribo. If it pleases the court, I will spend the first 7 minutes to address this court on the it does not provide for transparency, accountability, and human oversight. We advance two key arguments. First is on the right to fair administrative action. Second is on the compatibility with international refugee law. On fair administrative action, Article 47 of the Constitution provides that every person at paragraph 168 notes that the starting point is the question of lawfulness, and the test of lawfulness in that regard is whether the action that has been undertaken is provided in law, within the scope of statutory authority, and in compliance with the Constitution. we submit that the AIRSD fails this test for two main reasons. First, it offends Section 35 of the Data Protection Act, which provides that no data subject may be subjected to a decision that is solely on an automated processing or profiling which produces legal effects to that specific person. In this regard, if the court moves with me to paragraph 8 and paragraph 9 of the record, Mr. Warido is profiled by the AIRSD without any form of human oversight as required under Section 35 of the Data Protection Act. The second test is provided by the Court of Appeal's decision in Republic versus County Government of Mombasa ex parte Outdoor Advertising Agency, where the Court of Appeal reflects on the common law principle of non potest delegare. A delegate cannot delegate any further. Impliedly, as this court's advisory opinion, which is cited in that specific case, the advisory opinion in the matter of the Interim Independent Electoral Commission of 2011, the court is of the view that when a statute, and in this case, the Refugees Act, delegates authority to the Commissioner of Refugees under Section 12, Section 7, and Section 8, the Commissioner can only delegate that authority as either provided under statute or impliedly provided under statute. And under Section 12, that authority can only be delegated to a public officer under the Department of Refugees. It cannot, in this instance, as seen in paragraph 9, the profiling to a machine, or as seen in paragraph 8, the real-time assessment to a machine. In that regard, that action amounts to an unlawful delegation of statutory authority. Honorable members of the bench, bearing in mind the Court of Appeal decision in Mbalo Mutava and equally affirmed by this court's decision in Praxidis Saisi, when an action is entirely unlawful, this court does not necessarily have to look at whether that action is even procedurally fair. And Justice Ouko, in his concurring opinion in that specific judgment of the Court of Appeal as he was then, notes that an unlawful or unconstitutional action cannot be said to be procedurally fair because it offends the Constitution and the statute ab initio. In any event, we still submit that the decision is not procedurally fair to the extent that, inasmuch as it provides an appellate review mechanism, the requirement of written reasons under Article 47(2), whose consequence would be for the applicant who is aggrieved by that decision to confront such reasons, is not provided in this instance. In a human assessment, there would be reasons, or rather what we describe in our written submissions as intelligible reasons. What was considered? The starting point is what was to be considered, what was considered, and what was not considered. In the event that the applicant is pursuing the appellate mechanism provided in paragraph 8, the applicant will either confront what was considered or what was not considered, or rather what was not considered. When the same is not provided, the system is merely a black box where the appellate review mechanism becomes a procedural mechanism, but not what this court, what the High Court in Geoffrey Andare persuasively, while making reference to the Mbalo Mutava decision, refers to it that the fair hearing under Article 50 is rendered illusory. Lord, in this instance, while there is an appellate review mechanism that will satisfy the question of procedural fairness, it is not effective enough for one to mount an appeal. And finally, on the second limb of argument, on the question of compatibility with international law, the Republic of Nyota has ratified the 1951 Convention, which pursuant to Article 2.6, it is bound by the obligations arising under that convention. In this instance, the obligation, as provided in the United Nations High Commissioner for Refugees Procedure and Criteria Handbook for determining refugee status, states have an obligation to conduct a two-part test. One is the subjective and the objective. The AI only conducts the objective test. What do I mean by this? An objective test is that the AI pursues a certain objective. It cannot apply the principle under international refugee law, which is the principle of a benefit of a doubt. When we have political asylums, we have to apply the principle of a benefit of a doubt. An AI cannot perceive sincerity, and it cannot apply the benefit of a doubt principle. With that, we submit that the AI is unconstitutional, unlawful, and in contravention with the obligations of the state under the convention. I now cede floor to Ms. Mweke to proceed with our case.
May it please the court, presiding judge, your ladyships, my name is Joy Mweke and I appear as second counsel for the appellant. I will use the next 6 minutes to discuss, or rather to address this court on the third ground of appeal concerning the best interest of the child. We submit that the Court of Appeal erred in excusing the respondent's failure to consider the best interest of Warrido's children. Your Lordship, your Ladyships, by ratifying the Convention on the Rights of the Child, the Republic of Nyota is obliged to protect, respect, and fulfill the rights of all children within its jurisdiction, including Warrido's children, who are children first before they are refugees. Besides, Article 53(2) of the Constitution recognizes that a child's best interests are of paramount importance in every matter concerning the child. And this very court, in MAK versus RMAA and 4 others, decided in 2023, has clarified paramount importance to mean that the best interest of the child must be the determining factor to a decision pertaining the children. This also aligns with Article 3.1 of the Convention on the Rights of the Child and Article 4.1 of the African Charter on the Rights and Welfare of the Child, which mandates the consideration of the best interest of the child in all actions pertaining to children. But even locally, Section 8.2 of the Children's Act binds decision makers to treat the consideration of the best interest of the child as the first consideration. These provisions do not grant decision makers the discretion to cherry pick when to consider the best interest of the child and when to abandon them. We further rely, or rather are guided, by the Committee on the Rights of the Child in its general comment number 14 at paragraph 6, which notes that the best interest of the child is a rule of procedure. It mandates decision makers to show the impact of their decision on the children, how the right was taken into consideration, and how it was then weighed against other competing considerations. And if this court can move with me to paragraph 11 of the record, you will note that no individualized risk assessment was conducted at the point of issuing the deportation order. This is despite clear evidence of the imminent danger that the children would be exposed to upon return to Zephyria, which in paragraph 3, we note that there's an ongoing civil war characterized by mass execution, even sexual violence targeted against women and girls. And the importance of conducting an individualized test has been underscored by this very court in the same case of MAK versus RMAA at paragraph 85, which recognized that the best interest of the child as a concept should be adopted and defined on an individual basis, taking into consideration the unique nature of every child. These are children who have seen their parents being subjected to torture and incommunicado detention on multiple occasions. The psychological harm that they have undergone cannot be dismissed simply by citing the accuracy of the AIRSD, which we further submit was a blanket application that failed to consider children as subjects and not objects of the law. They are rights bearers in their own identity, as underscored by the High Court in SM versus DK and another, decided in 2024. But even finally pertaining to the detention, Article 53(1)(f) of the Constitution prohibits the detention of children unless it is a measure of last resort and for a short period of time. You will note that at the processing center, they were detained for 1 month and subsequently transferred to the holding center for a further 1 month. Your Lordship, your Ladyships, these children have been exposed to a world of violence and possibly even death upon return to Zephyria, and only this court can save them. We therefore invite this court to reverse the holding of the Court of Appeal, and having concluded my submissions, I cede floor to co-counsel.
Judge President, honorable members of the bench, my name is Kelvin Nyaribo, and I seek to address you on the second issue on the principle of non-refoulement, and the fourth issue on the encampment order and the holding of Warido and his family at the Nyairo Center. Turning your attention to the second ground of appeal, the appellant submits that the Court of Appeal wrongly held that the decision to deport Warido and his family did not violate the principle of non-refoulement. We argue that first, there was a real risk of persecution, and that second, there were no reasonable national security concerns to warrant their refoulement. On the real risk of persecution, Section 29 of the Refugee Act, as read with Article 33 of the Refugee Convention, prohibits return of individuals to countries where they may be at risk of political persecution. Persuasively, we rely on the European Court on Human Rights decision in Kruzvaras versus Sweden, where it held that the real risk threshold requires substantial grounds of belief of persecution and human rights violations. In this case, when you refer to paragraph 4, you see that Warido and his family fled Zephyria into Nyota because they were fleeing political persecution on account of their affiliation with the banned Democratic Liberation Party. Additionally, the parents have been on multiple occasions been subjected to incommunicado detention and torture. Besides, the civil war in Zephyria is characterized by mass enforcement and executions, disappearances of persons, destruction of villages, and even sexual violence that is targeted to women and girls. Therefore, there was a real risk of persecution, and the decision to deport them does not only violate the principle of non-refoulement, but the principle of prohibition against torture, which is a peremptory norm, under which no excuse can be used against the respondent. There is no excuse allowed in law because this is a peremptory norm. On the second aspect, there were no reasonable national security concerns to warrant their refoulement. Section 29 of the Refugee Act, as read with Article 33(2) of the Refugee Convention, allows refoulement where a person is regarded as a danger to national security on reasonable grounds. The Canadian Supreme Court has interpreted reasonable grounds in Mugesera versus Canada, that it requires more than mere suspicion. There must be an objective basis, compelling reasons, and credible information. In this case, there is only mere suspicion. The respondent decides to refoul Warido's family because they are at high risk because of their affiliation with the banned Democratic Liberation Party, which has been designated by Zephyria as a terrorist organization. However, the respondent cannot solely rely on the designation by the persecuting state as a reason of national security to warrant their refoulement, considering that also these are persons who have been subjected to torture, and they cannot rely on the political persecution that they are fleeing and turn it to a national security concern, and therefore again return them to that nation. And the Kenya National Human Rights Commission and another versus the Attorney General, and 3 others in 2016, held that the exception to non-refoulement must be narrowly construed, and mere apprehension does not suffice. It must be proved beyond reasonable doubt. Therefore, the decision to deport Warido and his family violated the principle of non-refoulement. Lastly, on the 4th ground of appeal, the appellant submits that the Court of Appeal wrongly held that the encampment order and the holding of Warido and his family did not violate the Constitution. We argue that it violated the freedom of movement and residence, and second, it violated the right to dignity. On the freedom of movement and residence, Article 39(1) and 3 of the Constitution, as read with Article 26 of the Refugee Convention, guarantees refugees the freedom of movement and residence. And we indeed acknowledge that this is not an absolute right, and it can therefore be limited. However, relying on this court's decision in Kandie versus Alassane Ba and another in 2017, at paragraph 77 to 79, any limitation of rights needs to meet the test of a reasonable and justifiable test. That is, meet the test of legality, necessity, and proportionality. We argue that the encampment order was disproportionate. The Court of Appeal in Attorney General versus Kituo cha Sheria and 7 others in 2017 held that mere suspicion of refugee involvement in insecurity cannot justify broad encampment orders. There is need to show an evidential linkage, and even if that is the case, it cannot be used as a springboard to introduce wide encampment orders. In this case, the respondents under paragraph 12 attribute the 4 terrorist attacks to foreign elements taking advantage of refugee involvement, or rather refugee mobility. They acknowledge it is foreign elements. It is not their citizens, nor the refugees who it has granted status to live in the country. And foreign elements getting past the borders of the nation is a security function of the respondent. And therefore, when they fail and foreign elements get into the country, refugees cannot be punished for this. And therefore, this was a disproportionate aim. And under Article 24(3), it is the onus on the state to prove that the limitation of right was justifiable. Seeing that our time is up, I request for 1 minute to conclude our submission.
You will have 1 minute.
Thank you for the grace, Presiding Judge. On the violation of the right to dignity, this is a right under Article 28 of the Constitution. Warido and his family were detained at the Nyairo Center. After being detained at the processing center for 1 month, they were also detained at the Nyairo Center for another month. This is a facility that has been determined to be inhumane, unsanitary conditions, overcrowded, and it is unsuitable for children. Persuasively, relying on the European Court on Human Rights decision in AA versus Greece, detaining an asylum seeker for 3 months in overcrowded places and that their unsanitary conditions amounts to degrading treatment. The Constitution under Article 25 puts it that subjection to degrading treatment is non-derogable. Under no circumstance should persons be subjected to degrading treatment. Therefore, there was a violation of the right to dignity. In conclusion, we ask that when this court retires, it finds that there is a declaration or gives a declaration on violation of the Constitution, grants further reliefs as we have sought in our written submissions, and it grants appropriate reliefs that it may deem fit, relying on your decision in Gitobu Imanyara in 2017. Therefore, we pray that when this court retires, may its pens be filled with the ink of justice. We yield the floor back to the court.
Okay, the respondent.
May it please this honorable court. My name is Angela Kiriga, appearing as lead counsel for the respondents. Appearing alongside me is Mr. Mshindi Walker and Mr. Francis Katitu. With the time graciously granted to us by this court, we will use it as follows. I will take up the first 10 minutes to discuss on
Just a
issue.
minute. Come up again with the names.
Right. I am Angela Kiriga, appearing as lead counsel for the respondent. I am joined by Mr. Mshindi Walker and Mr. Francis Katitu. With the time graciously granted to us by this court, we will use it up as follows. I will take the first 10 minutes to dispense with issue A and issue C. Mr. Mshindi Walker will take 5 minutes to dispense with issue B, and Mr. Francis Katitu will take 5 minutes to dispense with issue D. I beg leave to proceed. Thank you. Honorable Bench, the simple but central question to this issue is this. Would the same decision have been arrived at without the involvement of the AI? We aver that it would. We state that the AI tool used in the refugee status determination system was purely an assistive tool whose purpose was to collect data objectively and flag inconsistencies. We note by dint of the fact pattern that this was the case, that the AI system collected biometric data, it collected social media history, and it utilized behavioral patterns to arrive at its conclusion. It did not operate as a single system, absent of human involvement. Under Article 8, under Paragraph 8 of the fact pattern, we see that the AI RSD system operated under a small tribunal which was supervised by the jurisdiction of the High Court. We therefore aver that this mechanism was used in a human-led process where a human decision maker retained full responsibility of the decision that was arrived at. Moving on to Article 47 of the Constitution. This article states that every person is entitled to administrative action that is expeditious, that is efficient, lawful, reasonable, and procedurally fair. Faced with an exponential rise in refugee applications, the state undertook to innovate in administration by bringing forth the AI RSD system. Now, the courts have recognized that innovation in administration is permissible. We draw your attention to Republic versus KRA ex parte Yaya Towers Limited, where it was affirmed that administrative bodies may adopt new methods so long as they remain within the legal bounds. We further ask this court to be persuaded by the Supreme Court of Canada in the case of Hakshenas versus Canada, where the court upheld that the use of AI tools where human officers retain final responsibility was not a violation of their constitutional rights. We again stress that the AI's role was limited to preliminary and advisory functions, such as organizing data or flagging inconsistencies. Applying the proportionality test, Honorable Bench, the AI RSD meets every requirement. It pursues a legitimate aim. And the legitimate aim is that it was used to address delays and inefficiencies. And it has met that aim because it has managed refugee claims efficiently and fairly. We submit that this system was suitable. This system was rationally connected to the purpose for which it was used. Note that every determination made by the AI was factually accurate. We also submit that this system was necessary. There existed no restrictive alternative means which could achieve the same efficiency as this AI RSD system. Turning on to Article 50 of the Constitution, the right to a fair hearing was equally upheld. every AIRSD decision was subject to review by tribunal operating under the supervisory jurisdiction of the High Court. Now, the appellants have yet to demonstrate that they were denied the opportunity to be heard. Under the presumption of regularity, where the law provided an avenue for redress and the appellants did not pursue it, the presumption is that the right did exist and could have been exercised, but it was the prerogative of the appellant not to pursue this redress. We submit that every applicant retained the full opportunity to challenge or review an adverse decision before a competent authority. Moving on to the third issue, we draw this court's attention to the case of MAK versus RMAA relied upon by the appellants, where this court stated that the concept of the child's best interest is flexible and adaptable. It should be adapted and defined on an individual basis according to the specific situation of the child concerned, considering their personal context, situation, and needs. We also draw the attention of this court to the preamble of the Convention on the Rights of the Child, where it states that the family unit is the fundamental unit of society and the natural environment for the growth and well-being of its members, particularly children. Article 19 of the African Charter on the Rights and Welfare of the Child stipulates that every child is entitled to parental care and protection, and wherever possible, should reside with his or her parents. Flowing from the decision from this honorable court in Mudheu Agatha Kimulu versus Rahim Mehdi Aziz, this court found that a child has a right to parental care, and it is in the best interest of the child that he is brought up and cared for by his or her parent. It is with this in mind that the respondent chose to retain the children within the custody of their parents. We ask that this court be drawn to the decision of the Court of Appeal in the same matter, where it correctly appreciated that the AIRSD system had identified the adult family members as presenting a credible threat to national securities. Under such circumstances, Section 33(1)(a)(3) of the Citizenship and Immigration Act designates as a prohibited immigrant any person reasonably believed to be engaged in activities detrimental to national security. Section 33, subsection 2 of the same act extends this classification to dependents or family members of such persons, recognizing that administrative actions concerning security risks must treat the family as a single unit. Now, this approach avoids unnecessary family separation, and it ensured that the dependents remained under the care of the parents during the review processes. Therefore, the Court of Appeal rightly concluded that this inclusion of the children was not punitive, it was protective. It safeguarded their welfare while enabling the state to still discharge its constitutional mandate under Article 238 of the Constitution. We therefore respectfully urge this honorable court to affirm the finding of the Court of Appeal and hold that the respondent's conduct was lawful, it was reasonable, and constitutionally sound. I cede floor back to the court.
My lords and my ladies, if it may please this honorable court, my name is Mushindi Walker. I'll be presenting on the second issue, where it is the respondent's submission that the deportation order to Warido and his family was not a violation of the principle of non-refoulement, and the Court of Appeal was right to make that decision. My lords and my ladies, we do concede to the fact that we have a responsibility under Section 29(1) of the Refugee Act as read together with Article 33(1) of the 1951 UN Refugee Convention. But there is a caveat. At Section 29(2) of the Refugee Act, and as read together with Article 33(2) of the 1951 UN Convention, it is clear that the principle of non-refoulement can be derogated when there is national security risks. And this court has made it clear when it comes to limiting of rights. In the case of Kandie versus Alassine-Ba, the court stated that in limiting of rights, there are two things that need to be there. One, that the limitation of rights is lawful, as we have demonstrated under Section 29(1), and it's reasonable and justifiable. We like to make persuasive reliance on the case of Kenya National Human Rights Commission versus AG, which the appellants have made submission to. And in that case, Mativo J stated that in the application of Section 33(2), it should not be arbitrary nor blanket, that a decision should be stemmed from individualized risk assessment and a well-reasoned assessment of state security situation, according to page 12 of that judgment. Let's go to the first requirement of individualized risk. At paragraph 4 of the fact pattern, we can see that Warido and his wife are members of the DLP party, a designated terrorist organization by the Zafirian government. At paragraph 9 of the fact pattern, we can see the AIRSD made an accurate determination on this front. Therefore, individualized risk assessment was done. On the well-reasoned assessment of the state security, at paragraph 12, we can see that there were 4 coordinated terrorist attacks at September 2021. At paragraph 9 of the fact pattern, we can see that on August 2021, they were not deported immediately, but were held at detention centers. And the decision was made in September 2021, showing that there was a real security concern. We like to draw this court's attention to some apex court's decisions, particularly in the UK Supreme Court in Security of State for Home Department versus Repman, where the court stated that an individual must not in fact endanger the national security, but poses a danger to national security. Additionally, making reliance on the Canadian Supreme Court in Suresh versus Canada. In that case, Suresh was a member of a rebellion group, Liberation Tiger of Temal Elam in Sri Lanka. And the court found that the evidence of needing to demonstrate that someone is in fact a danger to national security is a threshold too high and should make inference to indirect factors. And it is our submission that Warido and his family, members of terrorist organization, do in fact pose a danger to national security. Therefore, our simple prayer to this honorable court, it holds the decision of the Court of Appeal that truly Warido and his family were a danger to national security, and it was made in that light. And with that, I'd like to submit the floor back to the court. I thank you, my lord and my ladies.
May it please this honorable court, my name is Francis Katitu. counsel for the respondent, here to converse on the fourth ground of appeal, seeking that this court upholds the decision of the Court of Appeal in holding that the encampment order was in fact legal and did not violate the constitutional rights of the Zephyrians, and the detainment of Warido and his family did not violate his inherent dignity. If the court so pleases, I shall proceed. The drafters of the Constitution of Nyota, while embedding fundamental rights in the Constitution, left a margin of appreciation, recognizing that the state would require some clemency in the protection of its security. This margin is found under Article 24 of the Constitution, where it states that rights indeed can be limited so long as they are done in accordance with the law and they are reasonable and justifiable. The case of Karen Jerry versus Alassane B.A. provides more interpretation to this provision. It states that first, there must be a law that provides for the limitation, and second, the same limitation should be reasonable and justifiable. Under the reasonable and justifiable test, it introduces three further subtests. It states that 1, it should be suitable, 2, necessary, and 3, proportional in the strictest sense. We, as the applicants, shall demonstrate that due to the 4 coordinated terrorist attacks, it was necessary for the encampment order to be issued. I will begin with the allowing law for this limitation. Under Section 44, subsection 2 of the Refugee Act for Nyota, the Cabinet Secretary is granted the power to control and regulate the movement of refugees both in designated areas and those who do not live in designated area. In satisfaction, or rather in acting in accordance to this power, the Cabinet Secretary for Internal Security issued the order that is the subject matter of this issue. Let us move to the purpose for this limitation. Because this court held, or rather, the courts have held, particularly in the case of Samuel Manumela versus Director of Justice and CMM versus Standard Group, that when the government wants to limit a right, they must provide some evidence to assist the court in making an assessment. This evidence will also assist the court in verifying whether the same measure was proportional as held by this court in Fatuma Adman versus Ruth Faith Mwasi. Let us go to the fact sheet, my lord and my ladies. Under paragraph 12, we are told that not 1, not 2, not 3, but 4 coordinated terrorist attacks happened. Further, we are also informed that the reason or the probable cause of these terrorist attacks was because of refugee mobility. Let us go to paragraph 4 of the fact sheet, where we are told that there was a civil war that was happening that was occurring in Zephyria. We are told that in Zephyria, there is a certain organization that had been labeled as a terrorist organization. We pose that rather inference that is highly likely that these members of this group that had been labeled as terrorists were the people who are moving from Zephyria into Nyota, and even evidenced by the terrorist attacks that were coordinated within Nyota as a result of refugee mobility. There is a high probability and a rational connection to believe that the two are linked. In conclusion, on that sub-issue, we urge this court to find that the encampment order was indeed legal under the law, and ask that it relies on the words of Randu Zuaira versus Minister of Internal Security, where the court held that in matters of national security, the executive arm of government is given a margin of appreciation. This is because it is the arm of government that is best suited to deal with such matters. The Minister of Internal Security, through us, the advocates, have provided the causal link between refugee mobility and the 4 coordinated terrorist attacks. We thus urge this honorable court to put that into consideration and to remember that the enjoyment of rights, that rights cannot be enjoyed in a state of chaos and in a state of terrorism. Further, and to address the question of whether it was justifiable to limit the rights. We rely on the Supreme Court case of Haki na Sheria Initiative versus the Inspector General, where as a result of terrorist attacks in certain affected countries, the Minister of Interior Security did issue curfew orders. In the same case, the Supreme Court held that indeed the freedom of movement and equality can be limited due to terrorist threats. This is because terrorism is recognized as both a domestic and international threat, requiring the invocation of the clause of public safety and public security. Further, it is not an entirely new concept to limit the right of movement. We've seen it during the COVID period in LSK versus Attorney General and in CM versus Attorney General, where restrictions put on counties due to the spread of the virus were validated by the court as necessary to protect public safety. We've seen that my time is about to end. I ask the court for discretionary 30 seconds to deal with the final limb of my argument.
The 20 minutes are done, so 30 seconds you have.
Much obliged, my lord. In conclusion, we shall address the issue of the detention of Warido. And while we do agree that they were detained for a period of 2 months, we must put this into the context that this was happening. Under paragraph 4, we are told that a myriad of refugees were moving from Zephyria into Nyota. It was not planned. Therefore, to contain them in a particular area and allow for the government to assess them and determine their refugee status, they had to be kept in a place. Owing to the fact that the place was overcrowded, we decided to utilize an automated facility that will both be efficient and expedient in assisting us manage the huge number of asylum seekers that had come. Further, we argue that the level of severity required to prove inhuman treatment and degrading treatment has not been proved in this case. Rather, the appellants rely on mere allegations of unsanitary conditions and deplorable conditions. This was stated in the case of George Nyanjori and Arab Republic of Egypt in the African Court of People and Human Rights, where a minimal level of severity must be met to occasion the violation of Article 28 on dignity. That has not been done in this case, and with that I cede back floor to the court. Thank you for your time.
Okay, thank you so much to both teams for your submissions. We now want to take a few minutes as the bench to find out some clarifications from your end. So any one of you can pick the question and respond to it. So I will start. Angela, counsel for the respondent. I want you to address the issue of the AI RSD system, whether it complied with the requirements under Article 47 of the Constitution of Nyota. Another issue I wish to also hear your comments on. You have alluded to the fact that the appellants did not challenge the administrative decision. I think maybe you are implying they did not exhaust the appeal mechanisms. We are aware that once an applicant in a matter involving the interpretation and the application of the Constitution is under duty to plead and particularize in very specific terms the alleged breach and violation of the Constitution. From the fact pattern, the applicant have done that. Why do you feel the burden has not been discharged in this month. Then number 3, on the question of Article 23, submissions have been made to suggest that since Warido had been assessed by the AI system and found to be a threat to national security, then he should be lumped together with his children. We have had submissions yesterday that this court, the Supreme Court, has held in a number of cases, the latest being Fatma Atman, that the children cannot be allowed or cannot carry the sins of their parents. So I want to hear your submissions on this, why Warido's children should be made to carry the sins of their father. I think on my part, that is what I only have for the parties.
Thank you so much for your presentations. Just also as a rider question to the use of the AI, in looking at the Coalition for Reforms and Democracy case versus the AG, in that case it was said that the principle that any automated or any other process like this by the use of AI, with legal effects, must be fair, transparent, and accountable. And before such a process is utilized, the parties should be informed. They should be prior informed, and there should be prior informed consent by the parties. So by failure to do this by the state of Nyota, then in that way, did they then violate the rights of Warido and his family, despite the huge number of people? Because you have argued that the reason why this system was used, there was floods and floods of people coming. Despite the floods and floods of people coming, was this process fair? Was it accountable to the people that it was being given to? And if not, then in that sense, did the state fail in its mandate to protect even the refugees, noting that they have also signed international conventions in regards to this? Thank you.
Okay, sorry, I had forgotten only one issue. This is to Ayaga, or is it Ayaga? The issue of the doctrine of exhaustion. The submissions have been made that you did not invoke that. Why did you run to court without invoking that doctrine of exhaustion? You can comment on that.
Okay, thank you very much for the very insightful presentations, and also congratulations for coming to the quarterfinals. It says that both of the teams are equal to the task, and I think we are impressed. So I think I'll just have a rider on the issue for the AI, and I believe this was to the respondents. That was Kahiga's submissions. You made a comment to the effect that the AI was factually accurate. So I wanted to pose a question to you. For you to determine something is factually accurate, I do believe the information fed into the AI machine is fed by individuals. So in the instance whereby a person is not factually correct, will the information captured by the AI be factually accurate? Thank you.
Yes, we'll begin with the respondents. You respond to the questions, then the applicants, as you respond to the questions, you will then proceed to use your 5 minutes for rebuttal.
Most obliged, honorable bench. And to the questions that have been posed to the respondents, I will respond to the following. The first is on whether the AI RSD system complied with the provisions of Article 47. And the second question I will respond to is on whether the appellants exhausted or did not exhaust the appeal mechanism. On the first question, I submit that the AI RSD system did comply with the requirements of Article 47. On the requirement of lawfulness, we submit that the Cabinet Secretary for Ministry of Home Affairs is empowered to come up with administrative actions that address the challenges arising from such unprecedented events, such as the influx of refugees within the state. On the aspect of transparency, we note that nowhere in the fact pattern is it indicated that the respondents, the appellants, were not notified of the written reasons of why they had been flagged as high risk. Note that state organs enjoy, or rather can rely on the presumption of regularity, which states that where a state organ has a procedurally required process, unless the appellants prove that this was not specifically done, then it is assumed that the same was upheld. On the question on the appeal mechanism, we understand that this court, that when a matter reaches this court, this honorable court, the preliminary issue of admissibility, and specifically on the exhaustion of local remedies principle, has already been dispensed with, and therefore we do not rely on it as to demonstrate that this need was not met. We do feel, however, that the appellants had an opportunity to pursue this method and opted not to. And that is within their prerogative. But we cannot again ask this court to sanitize their inaction as a violation of their fundamental rights. I still floor to my co-counsels to handle the rest of the question posed to the respondents.
Most obliged, my lord and ladies. In answering the honorable judge's question on whether the children of Warido are suffering the sins of Warido himself, to this, first we note that the matters of children are sensitive, and we also do submit to this court that the respondent, in conducting its action, has put into consideration its legal obligation to follow the best child's interest. The best child's interest is a right guaranteed in the Constitution, but there needs to be balance. One is that we note that Warido and his wife are members of a terrorist organization as background to the question. Number two, the UNHCR guidelines on the formal determination of the best child interests has 3 key points. Number one is that optimally parents are the ones who have the best child interests at heart. But in this case, the best child interests are with parents who are refugees. And the Republic of Nyota will not like to separate the parents from the children from the parents who have the best child interest. And it is our submission that truly they are not suffering the consequences, but from the decision of the respondents, it is in the best child interests that they are refoiled together with their parents. If that suffices, I do thank the bench and cede floor back to it. Thank you.
May it please the court, Francis Katitu, to answer the final question posed by her ladyship on the assumption on whether if the facts that were input into the system were factually incorrect, then what will happen? I'll answer that in two limbs. So first of all, in a normal scenario, assuming that the AI RSD does not exist, it will be a human, it will be a human taking up the information and the human making the decision. But what the AI RSD does, yes, the human will input the information, but it's the AI RSD that will make the decision, making the decision, one, non-biased, and two, more objective. Secondly, if someone has a problem with the facts that were input or claims that the facts were incorrect, there is a small administrative tribunal that is provided for by the refugee commissioner to appeal such decision, and the same is supervised by the High Court, and that's why we are here today. So such an issue will not arise because there are enough mechanisms that have been put into place to ensure that to the largest extent possible, the information that is fed into the AIRSD system is correct, and the decision that will finally be made is to the best interest of the parties involved. Much obliged. I cede the floor back to the court.
My ladies, my lord, I will respond to the question posed by presiding judge and then give the rebuttals. My lord, on the question of the doctrine of exhaustion, the issue first of all here does not only concern Mr. Warido, it equally concerns, has been brought by the coalition of refugees. And the constitution under Article 22 provides that any person who is aggrieved by a decision that offends the constitution or is a violation of their fundamental rights may approach the court in reference to the same. And this court's, in the celebrated decision in Anarita Karimi, what we are supposed to do basically is to prove that there is, with a lot of specificity, the provisions of the constitution that have been violated or the specific right that has been violated. In this instance, we have actually satisfied that test. We have shown that Article 47 has been violated, and we've gone ahead to list the provisions or the elements of that specific right that has been violated. Equally, we have provided under the right to a fair hearing how it has been violated. Therefore, it cannot be said that we have not satisfied the test in that regard. In any case, we have an issue. If we are to take the response by the respondents' counsel in reference to your question on why we didn't pursue the appellate review mechanism in reference specifically to Mr. Warido, it's because we have an issue with that appellate review mechanism, that it does not provide an effective review mechanism. An effective review mechanism would only be there if there are intelligible reasons. I started by saying we need to know what was to be considered, what was considered, and what was not considered. We cannot appeal what we do not know the background basis of. In simple terms, we have a review mechanism that is simply meant to tick the boxes of what amounts to a review mechanism. Now, to begin our rebuttals, I will start by the respondent poses a question as to whether the same decision would have been arrived at by a human. My lord, my ladies, we do not have an issue as to whether that decision would have been arrived similarly by a human. But the court's decision and the concurring opinion by Justice Ouko in Mbalo Mutava is that the starting point is that arrival itself constitutional? Is that arrival itself legal? The moment it is not legal, it is immaterial whether any other human or any other entity would have arrived at that decision. The decision in this instance, and taking the respondent's arguments that normally in the instant case, a human would have received the information and made a determination, and in this instance is the human receiving the information and then feeding on the AI and the AI making the decision. That is precisely the problem we have in reference to the extent that it is violating Section 35 of the Data Protection Act. The respondents equally cited the case of Republic versus KRA ex parte Yaya Towers. We agree with the respondent to the extent that the court said starting a new technology does not violate the law. However, that technology itself has to be in accordance with the law. We submit that the technology in this instance is not in accordance with the law to the extent that is violating Section 35 and equally amounting to a delegation of statutory authority, which is unlawful. On the same paragraph 5 of the preamble that the respondents have cited on family fundamentality as a fundamental unit of the society, the same paragraph 5 of that preamble places an obligation for an object and purpose of the convention to protect the family unit. Taking the family unit back to Sevilla will torture the family unit, will end up having detention and all that. That is not the object and purpose of the convention. Equally, Council relied on the Mudeu Agatha Kimilu versus Aziz Azad to justify the importance of parental care, and that is the reason why they had to deport the parents, or they make the decision to deport the parents and the children. But parental care will not exist when the parents have been detained or when the parents are tortured. And finally, in reference to the decision that was cited, that is the Kenya National Human Rights Commission versus AG on risk assessment. Lord, it is quite evident in paragraph 3 that these individuals face a threat to life, have been tortured and subjected to detention. Persons running away from torture and detention cannot pose any risk to a state. In any case, again referring to the same Court of Appeal decision in AG versus Kituo cha Sheria, which has been cited by the respondent, invocation of national security cannot be speculative and must be backed by clear and cogent evidence. In this instance, there is a designation by a persecuting state which has refused to cede office and has now designated the opposition party as a terrorist organization purely for political reasons. We cannot rely on a designation of a persecuting state. With that, this court has been called for the first time and at a very critical time to make a determination, a precedence that will not allow, first, the use of automated systems without accountability and the trading of justice for expedience. We rest our case and cede floor back to the court. I thank you, honorable members of the bench.
Okay, so we are done, and we will not get tired congratulating you for all the effort we are seeing you put in. We will consider your submissions, and in a short while within the day, we will make our decision on the matter. So we come to the end of this session. The court adjourns.